Thank you so much, Mr. Mokua, for generously setting housekeeping rules. Once again, good afternoon. Ladies and gentlemen, I bring you very warm greetings from the Secretariat of the East Africa Law Society. Greetings from the Chief Executive Officer, Mr. David Sigana, and the management team at ELS. We welcome you to the month of August. This is a month of good things only. So expect the very best from the Secretariat. We have a lined up schedule for you. I'm sure you were able to look at the calendar that was shared at the beginning of the month. So look out for very informative capacity building sessions that are organized by our different committees. And we bring you very experienced personnel to come and discuss these various aspects with you. That said, ladies and gentlemen, I would like to take this opportunity also to inform you that we are having our in-house council convention on the 5th and the 6th of September 2024 in Watamu, Kilifi, Kenya. So if you're in-house counsel and you're logged onto this call, or if you would like to participate in the in-house counsel convention, please feel free to check out our website and register for that. It's going to be the biggest gathering of in-house counsel in Eastern and Central Africa. So you do not want to miss that. And in the last week of September, we'll be having the construction law and FIDIC contracts training session. This will be happening in Kigali, Rwanda, the land of milk and honey. So you do not want to miss that particular workshop. If you're an enthusiast and you want to know more about FIDIC contracts and construction law, please register for that training and you'll be able to attend. Now back to the business this afternoon. This afternoon, we are honored to have a distinguished panel of senior practitioners from across the region that are moderated by our very able-bodied Mr. Mokua Manyara. Mr. Mokua Manyara serves as the ELS chairperson of the Young Lawyers Committee. He's an advocate of the High Court of Kenya, a certified legal and compliance auditor, and an ardent and compassionate sports lawyer. He has over 4 years' experience as an advocate of the High Court of Kenya with pedigree in litigation at superior courts, and he's handled noble cases that in Kenya. For those of you who know Mokua, he's been around the field. Now, he's joined by the chairperson of the TLS Young Lawyers Committee, Mr. Ukashu Emmanuel, who swept victory recently. So congratulations, Ukashu. And he will be co-moderating this webinar session with Mr. Mokua. Without further ado, ladies and gentlemen, allow me to invite Mr. Mokua to come and moderate this session. We have until 4 p.m. to hold our discussions and finalize with items on the agenda. Please note that you will be given an opportunity to ask questions, but also at the end of the webinar session, we'll share a recording of the same with you, and you will be awarded a certificate of attendance of this particular webinar session. So enjoy, have fun, ask questions, and let's explore together. Over to you, Mokua.
Thank you for the kind and very powerful introduction, Mr. Gabriel. I didn't know I am that good. Allow me to jump straight into the webinar for the day. We are talking about essential communication skills for young lawyers and creating and developing good client relationships. So in this webinar, we seek to understand the importance of effective communication in legal practice, to discuss the essential communication skills that every lawyer must cultivate in their practice, to discuss the different tools for effective communication with clients, and to discuss the strategies on how to cultivate good long-term client relationships. So our first speaker for the day is Mr. Mohamed Nyauga, EBS Senior Counsel. He has a long profile, but allow me to do justice to this profile. Mr. Mohamed Nyauga is the former chairperson of the Central Bank of Kenya Board of Directors and former chairperson of the International Monetary Fund, Washington External Experts Panel. He's currently a trainer for the IMF in central banks, governance for central banks, and capacity building regional forums. Mr. Nyaoga is also a senior counsel and a senior partner at the law firm of Mohammed Muigai LLP. He holds an LLB and LLM degrees from the University of Nairobi and also a higher diploma from the Kenya School of Law. He is a certified public secretary, holds a certificates actually in corporate governance from the Commonwealth Association of Corporate Governance, certificate from the American Securities and Exchange Commission, a certified company director and a member of Institute of Directors of Kenya. He specializes in corporate finance, civil, commercial, litigation, and corporate governance. In addition to the practice of law, he has been vice chairperson of the Law Reform Commission, the chairperson of its Business Laws Committee, and chairperson of the Ministry Mining License Task Force. He has been a director of the Capital Markets Authority, the chairperson of International Commission of Jurists, council member for the Law Society of Kenya, special board corporate governance advisor, and chairperson of EcoBank, Kenya. He has been chairperson of the Commission of Inquiry into the suspension of the county government of Makueni. In addition, Mr. Nyaoga is a certified training consultant in corporate governance with the Center for Corporate Governance with over 22 years, where he has trained several boards in Kenya and globally. He is also a consultant and trainer for the State University of New York on procurement, that is SUNY Kenya, and a lecturer, LLM program at the University of Nairobi. School of Law, Business Law Department on public procurement and accounting law. He is currently a regular trainer and speaker at the Central Banking Publication UK Governance Training Series at Windsor, Cambridge, and Oxford, and also one of the authors and editors of the Central Banking Publications. If we continue reading this profile, I think we might not have our webinar today. So allow me, with the brief introduction, to welcome Mr. Mohammed Nyaoga, our first speaker. I know most of us are waiting to listen to you and also to draw lessons from your 40 plus years as a legal practitioner. Mr. Nyaoga, the floor is yours.
Thank you. Thank you very much. And in fact, first and foremost, I think my name appears there as Mukoa Manyara, but I think that will be sorted out shortly. Ladies and gentlemen, I'm indeed very delighted to participate in this session. This is a very, very important part of legal practice for any lawyer, not just young lawyers. But again, during this session, I'm going to learn also
Mr. Mokua, I think we have lost him.
Please, I think there's a network issues. Let us resolve. Leading moderator, Mr. Mokua, please guide us.
Yes. Well, apologies for that. Given that we have lost senior counsel and we're also trying to sort out his public profile on this webinar, would we please then invite Mr. Ukashu to introduce Ms. Alice Namuli for us so that she can take the floor as we wait for Mr. Nyaoga to be back.
Thank you, Mr. Makua. Let me introduce and good afternoon, all attendants and participants in this very important webinar session. It's my humble submission that I'm introducing.
I think I'm back.
Oh, you're back. Okay. Well, please proceed, Senior Counsel.
I was knocked off, yeah. So what I was saying is that I've learned that the most important strategy is willingness to learn. And whatever strategy that I'm going to share with you, or strategies I'm going to share with you, as a reason for my learning, the process of learning, my experience in practice. And I have no intention of actually abandoning this learning. So there are certain things that I've learned about client relationships in my career as a practitioner. But again, in a topic such as this, there's so much to say. It's just like any other relationships that we enjoy in human social interactions, the advocate-client relationship is basically based on trust. It is constructed upon trust and confidence. Any strategy must therefore depend on building of trust. As a practitioner, you must build trust with your clients. But again, to do this, there are a number of things that you must do. Your clients must trust and believe in you. But they can only do so if you are competent, if your advice is sound, so that you can be trusted. So therefore, the first investment for any lawyer is upskilling. The greater you'll be consulted more, but also
Senior Counsel, we seem to have lost you.
Senior Counsel, I think you are lost. Allow me to introduce Alice as you are coming, Senior Counsel. Mr. Makua, I hope I have to introduce Alice as Senior Counsel is getting prepared of his network issues.
Yeah, that's okay.
Let me introduce Alice Namuli. First and foremost, she's a partner and the head of tech and innovations of Katende Company Advocates. She's an award winner, lawyer, and most notable for top 5 most influential women in legal tech by the International Legal Tech Association 2020. She's an innovator, international speaker, author, and a thought leader in the legal tech sector. She has over 18 years of experience specializing in technology and the law, with a keen interest in artificial intelligence, blockchain, cryptocurrencies, cyber law, and data protection. She represents most of the largest fintech and blockchain technology based in business, which are reshaping the mode of doing business in Africa. She has a background in PPP, infrastructure project finance, merger and acquisition. She serves as a board member or non-executive director for various fintech in Uganda. She's a member of Innovation and Investment Board for the National Social Security Fund, NCCF. She's a cyber security expert for the Security Institute for Governance and Leadership in Africa at the University of Stellenbosch, South Africa. She is a faculty advisor on Digital Legal Exchange, a global training institute for leaders in the digital world. She's a co-founder, Legal Innovation Hub Africa. She's a co-founder, African Innovation Law and Tech Academy. She's a co-founder of Kampala Legal Archives. So it's my humble submission that I welcome you, Alice, for your presentation, while the Senior Counsel will be taking to solve with issues of network. Welcome, the floor is yours, Madam Alice. Welcome, Senior Counsel.
Thank you very much. Hope I'm clear. Just give me a note.
Yeah.
Okay, very well, thank you. Yeah, so I was given this topic to share, which is essential communication skills that every lawyer must cultivate to excel in their practice. I'm making 20 years in October. So I've been around for a while, and I'm happy to share some of the things that I have seen, I have experienced, and I think that definitely can be able to help the members on the webinar today. The previous speaker actually talked about trust. I also have it in there, but I also think it's actually one of the key things. But I'll start with active listening. Many of us lawyers, one of the things I realized, we like to talk. You understand? We like to, and also to give solutions to our clients, quick solutions. So the first thing, so a client walks in, and then you're very quick to give them a solution, meaning, oh yes, I know what you mean. I know exactly what you're talking about. I've handled that case before. And then before even the client has fully expressed themselves, you're very quick to interject and give your advice. What I've learned is that it's important to actively listen and understand your client. Understand what they're trying to communicate to you. Show empathy. Try to fill in their shoes. Try to be in their shoes, and fully appreciate what they're trying to communicate to you. Then be able to respond. Without that, then you'll end up giving solutions to something that most probably they were not, to something, you might end up providing solutions to an issue that pretty much was non-existent, or partial solutions, finding out partial solutions, because clearly you didn't understand the instructions. So understanding client instructions is extremely, extremely key. Then being very, very clear and concise, whether in writing and also when you're speaking. You have to be, whether you're writing an email, whether it's writing a brief. Actually, the best thing usually is after you've taken the instructions from the client and actively listened and understood what they're trying to communicate to you or ask from you. You can write a brief and share it with a client, and inform the client, actually just to confirm that, you know what, with reference to our meeting we had, whether online or physical, this is a summary of what we actually agreed on, so that the client can confirm that you actually were able to understand their instructions. That usually helps a lot, especially if a meeting was long, or there are so many issues that most probably you needed as kind of clarification, and also just to ensure that pretty much you're on the same page. So just be as clear as possible and concise. The other thing I would also like to talk about and emphasize is nonverbal communication. This is, I think, the most important, and we want also to communicate, to emphasize it. We communicate as human beings, we communicate differently. You'll be very surprised that as soon as you walk into a room, someone is able to know who you are in the first five minutes before even actually you interact or even say anything. It's the way you sit, the way you've dressed, the way you've even the makeup you wear, the jewelry, all these things communicate. We communicate through our clothing, the way we walk and the way we sit. So that is also something you have to be very careful. When you walk into a meeting, do you walk in with confidence? Because that actually can show. Your body can show that, my lawyer doesn't seem to be very, confident. Or are you shabby? Have you walked in? Do you have like smelly clothes? All these things, by the communicate, it shows that you're not kempt. If you're not kempt, how are you able to actually then to do, neat work? Many people, you'll be very surprised how they pick up all these clues and they're able to know that, to have confidence in their lawyer, or to withdraw instructions. Are you disorderly? There's some people walking into meetings, there are papers flying, here and there. You could be the most brilliant lawyer, but if you come in scattered, not organized, then your client might definitely kind of lose confidence. And most people think that the non-verbal the way we communicate is strictly through our mouth. But unfortunately, it's our facial expressions, the way we twitch, the eye contact. Many times you're speaking to someone, but they're constantly looking down. So if you're a client, you kind of doubt whether this lawyer is actually being genuine. Why would you be looking down? Why don't you look in the eyes of your client? You have to look straight into the client. Have a straight, body posture. You make sure as much as possible you don't, have less movement, in your face, because some people get very kind of irritated. Why were they kind of twitching? Were they telling the truth or not telling the truth? Anyway, I want to really emphasize on body language, or what I would call nonverbal communication. It's just one of the best things that to get right. Before you speak, you say anything, just make sure that your body, your face, your clothes, everything is communicating what you want to communicate to the client. The other thing would be adapting or to the situation, being pretty much flexible, depending on the kind of audience you're going to. If you've had my CV. I work a lot with tech companies, and most of the these like techies are very young people, and they like very informal setups. They like to meet online. They like digital to communicate digitally, whether it's using e-signatures, whether it's they want less paper. Now, what am I trying to say is, if you know that you're in that kind of space and you're working with this kind of people, you have definitely to adapt. Because some lawyers would be like, want to insist that, no, you have to come to my office, we might have to meet physically. Unfortunately, these people operate in a virtual world. Everything in their world is virtual. If you're the lawyer then who is going to insist, I have to sign that document, I have to sign it physically, I have to come to your office and sign it, you bring it to my office, they'll definitely have to move on, and they will move on and look for a lawyer who understands them. So adapting to your audience is extremely important. Then you could find, there are some clients who love the formality, like you're going to walk into a bank or you're walking to a court. Just know, if I'm going to court, what am I required to wear? If you're going to before a judge or a magistrate, even just lawyers attire, just knowing what pretty much to do. Knowing your audience is extremely important. Learn it beforehand, know where you're going, and please dress accordingly, or communicate accordingly. And also, definitely, when you're communicating, try as much as possible not to complicate. The people always don't like the way people think that clients think that we complicate, lawyers, we complicate scenarios because of our jargon. So try as much as possible to break down whatever you're communicating to your clients in a most simple way, which can be understood by an ordinary person. Just imagine you're communicating to a 12-year-old or even a 10-year-old. Make it very, very simple. Don't complicate things and say, what, bring in, I don't know which Latin words and everything. That could be between you and your colleague. But just don't say that, when you're communicating to your client. Make your client feel you and understand you. The first speaker was trying to mention something about trust. I think, to me, if you don't, you're not in sync with a client. How do you get in sync with a client? You must earn the trust of that client. And when you're in sync with that client, then you move at the same pace. You're at the same level of thinking. You're understanding each other. The client is not even doubting your advice. That is extremely key. Because when you're off balance, the client does not understand actually the language you're speaking. Meaning, I'm not saying the language like English or Swahili or whatever. What I mean, the things, what you're trying to tell them to do. Sometimes we, even the solutions, we try to provide a very underhanded. So you find, if you don't understand your client, a client who wants, maybe straightforward solutions, but then you're trying to take him, in circles, taking him in zigzag, that people get overwhelmed. Try to understand the culture of the person, the client you're serving. Where do they come from? Who they are? Which company they work for? What are their policies? What is their culture? Then you try to communicate that language. And when I say language, I'm not talking about literally the language or the spoken language, English and whatever, Swahili or whatever language everyone speaks, or French. So being at the same level, being at the same wavelength, speaking the same language with a client is also extremely important when you're trying to communicate effectively with a client. I would want to stop there for now, and I guess call in my colleagues who, I don't know if he's back. Moderator, can you confirm if the former speaker? Oh yeah, he's there.
Yes, senior counsel is back, so I think
Okay.
you can break for a while, and Mr.
Okay.
Senior Counsel Mohammed can proceed. Then we'll get back to you because there are some key questions you will need to interact and for pause in order for the participant to understand or to make some deliberations too. Welcome, Senior Counsel Nyauga.
Thank you very much. Apologies. I think I was thrown off, and I'm back now. And at the point at which I was thrown off, I think I was talking about trust, building trust. For you to be trusted by clients, you need to upskill. You must be competent, and if you have that competence, the advice you give is more likely to be taken seriously by the client, because you speak with authority. So lawyers must upskill, reskill, learn, and unlearn. You must invest in your skills. I've come across lawyers many times who say, look, I've not been given this sort of work. Why is so-and-so given this sort of work? But the question you ask yourself, are you ready for that sort of work? So you must upskill. And once you upskill, the pronouncements that you make to the clients are more likely to be taken much more seriously in whichever area you are being consulted on. Secondly, trust. Skill alone cannot count without integrity. You must have integrity. You must be worth of your trust. Because today, if you tell a client that I'm going to be in court tomorrow, and you don't appear, obviously, you will be a person who has no integrity because you don't mean what you say. It is important that we keep our promises that you make. Integrity means that you keep your promises. It must be keeping promises that you not only make to other people, to your clients, but also to yourself. It is what you do when nobody is watching. Once trust is broken, it cannot be restored. So when it comes to integrity, there is really no margin of compromise. You can't say this was a small issue and therefore I need to be trusted. The impact of lack of integrity, whether small or big, is huge. So it doesn't matter. You can't say that you can have some integrity. No. The question marks about integrity have the same impact whether the question mark is small or big. But again, how do you build trust? You build trust by ensuring that what you promise is fulfilled. If you promise the client that you are going to draw up some document or some pleadings, or you are going to appear in court at a particular time, you must appear. You must draw those documents within the time that you are promised. If you're holding money on behalf of the client and you promised that you are going to release that money, your promise is your bond. You must release that money at the time which you promise you are going to release it. Ladies and gentlemen, the client will not forget if you promise to release money on a Monday and they can't reach you on phone. Because what happens, you're going to be known as a lawyer whose phone always breaks down, that you can't be reached. And if that happens, that word will spread to other clients and nobody will trust you. Nobody will come to you because the trust has been broken. Thirdly, you must be transparent. There are many cases where lawyers say the work is going to be very easy, this is very simple. But later, when they're charging fees, they'll tell the client, the brief was very complex just to justify fees. Fees is a very sensitive issue. And if you do not clearly agree with the client and manage expectations, it is likely to bring about conflict and it will erode the trust that we are talking about. So what is my advice? My advice is that try and be as transparent as possible. Clients don't like surprises. Make sure the communication is clear. Trust is effective in two ways. One, when you have trust, you win clients. But when you have no trust, you lose clients. The best marketing is by word of mouth. Because some of the referrals that we get from clients or from lawyers or other people is by word of mouth. And this is much more powerful than you putting out an advert yourself saying we are X law firm and we do X, Y, Z, and we are competent, etc., etc. Social media, we advertise out there. We do self-advertising. But the most powerful tool is review by a third party who is disinterested. And the impact of such an endorsement from a third party is extremely powerful. It supersedes any self-selling that we try and engage in ourselves. It is the same in law. Clients talk to each other. They also do due diligence on us. We do due diligence on behalf of clients or on clients. But they also check around. they try to find out from other clients or other lawyers whether you can be trusted. And once trust is established, clients will always come back to you. They always come back to you. They will seek advice in different areas, not necessarily areas of your expertise. And once you give the advice, which is trustworthy, which is competent, this will increase the levels of trust. Ladies and gentlemen, you can build trust, but you must maintain it. It means that you must be consistent in your service delivery. The good work that you did for a client last time will not salvage the shoddy work that you do today. You do a very good job for a client, you go to court, argue a case, you win it. But if they come to you subsequently and you do shoddy work, that will be it. The goodwill that you have earned today is a perishable product. So therefore, you must be consistent and you must maintain that trust. You must go an extra mile. You must understand your client's needs and you must respond to them. Again, sometimes it's not all about charging fees. It's not all about billing. You must be prepared to provide additional value to the clients. You must be prepared to offer solutions to the clients. They may confront you with a legal issue, but you may offer them advice around that legal issue that will give them solutions. And if you do so, the client is going to notice that you are attentive to their problem and to their interests, and that you hold them dear. Let me say something about the use of technology, ladies and gentlemen. Technology is important because it is the age now we live in where technology is very critical. It's important for law firms, for client management, to manage our communication, to manage our billings, to also improve our efficiency, and make our services much more accessible to our clients. But there's no substitute to personalized service, ladies and gentlemen. The technology should supplement, not supplant, the personal element. I say this even in this world now of digital relationships. Many of the clients that we enjoy today, the relationship we enjoy today, are as a consequence, are as a result of personal relationships. I also know that through personal interactions in court, in coffee houses, etc., we're able to actually get referrals or refer clients to other lawyers. Of course, in our country now, one of the challenges we face is that we are doing most of the cases online, and we are missing this part of interaction that perhaps can lead to referrals or cross referrals of clients that can help the lawyers also develop opportunities for themselves. I think I'll stop there for now. Thank you very much.
Thank you, Senior Counsel. If I could summarize what I have learned between what Senior Counsel has said and what Ms. Muli has said, trust is one of the critical things that we need to cultivate with our clients. We must also be very, very willing to learn. We must be consistent. We must be active listeners. We must also be ready to adapt to our clients and to the audience of the modern world. Use simple language when communicating with clients. We should not use Latin words. And then we make sure that we are in sync with our clients. Be job ready by upscaling constantly. Understand client needs and respond to them adequately by providing solutions, and actually give additional value. Now, friends, we we continue hearing from various speakers this afternoon. If you could allow me, I'll also invite my good friend, Mr. Ukashu, to invite the next speaker, who will also take us through. I think Mr. Ukashu will introduce Mr. Ndamugoba. Mr. Ndamugoba also have a presentation for 10 minutes, and then we proceed. Mr. Ukashu, please.
Welcome. Thank you, Mr. Manyara. Okay, let me introduce Senior Counsel, my brother Sunday Geoffrey Namugoba. Senior Counsel Namugoba is a partner and a chief innovation officer at Reeve and Company in Dar es Salaam, where he leads the intellectual property and the technology department, leveraging over 10 years of experience. His expertise spans intellectual property, IP, technology, privacy, and data protection laws, as well as investment law in Tanzania and Zanzibar. Namugoba pros in intellectual property laws as he earned recognition from WTR 2024, which recommended him as a trademark attorney in Tanzania and Zanzibar. He's renowned for the provenance in trademark and patent registration, having successfully registered trademarks and patents for clients in Africa. As an authority in intellectual property law, he places particular emphasis on trademark law and fair competition, copyrights, design, intermediaries, liabilities, artificial intelligence, content issues, and data protection. On investment, Senior Counsel Namugoba has provided counsel on diversity area of projects encompassing local content matters, merger and acquisition, company restructuring, and infrastructure projects, international trade, rules of origin, supply chain management, transport, African Continental Free Trade Area, AFCTA, and other related regulatory compliance for both local and international clients. He also advises companies on the IP component of mergering and acquisition and asset dealing and other commercial arrangements in the M&A context. Beyond his responsibility at the Reeve & Company, Namugoba holds various provisional affiliations and positions. He's an advocate of Tanzania, High Court of Tanzania, and High Court of Zanzibar, a member of Tanganyika Law Society and East African Law Society and Zanzibar Law Society. Additionally, he served on the governing council of the Zanzibar Law Society and as a coordinator of the Continuous Legal Education Committee at Zanzibar Law Society. Furthermore, he is a member of the International Trademark Association, chairman of the Intellectual Property Committee at the East African Law. Can you hear me? Please. Okay, I was pausing there. I'm continuing. Let me get. He's a member of the International Trademark Association, chairman of the Intellectual Property Committee at the East African Law Society, and the UK Chartered Trademark Attorney. Namugoba is also an arbitrator with Tanzania Institute of Arbitrators and registered arbitrator and a mediator with the Ministry of Constitution and Legal Affairs. In summary, Sunday Geoffrey Namugoba multifaceted experience in intellectual property, technology, and investment law, making him a respected and valued resource for clients seeking guidance on the wide range of legal and regulatory matters in Tanzania and Zanzibar. With this brief bio, it's my humble prayer that I'm welcoming Senior Counsel Namugoba. Please, the floor is yours. You have got 10 minutes to make a presentation in order we look for another session for deliberation. Welcome, Senior Counsel Sunday Namugoba.
Thank you very much, Emmanuel. Much appreciated. I know I have 10 minutes, so I'll be very, very quick. Thank you, everyone, for joining us today. I've been already introduced. So I'm tasked to speak on the effective communication tools for lawyers and their clients. That would be my main area today. I've divided into 4 sections where I would be speaking about the internal and external communication tools for lawyers. I'll look into project management softwares, the client intake and relationship management. I'll give a brief of what case management software caters in terms of client relationships, and the virtual receptionist services and secure video conferencing, of which also caters as a tool for communication. So starting off with internal and external, I'm basing this on the experience I've had at Rive & Co. Because for most, as you know, many law firms do communicate with clients, but the aim is to build better relationships and then also to pretty much improve the communication that is there between law firms and clients. So I'll give you tips and tools that I think will help you, as they have helped us as a firm. So how do lawyers communicate with their clients? I believe there are so many ways. There are traditional ways and there are non-traditional ways. What Senior Mohammed Wigai was talking about in terms of, for example, phone calls, emails, and the likes. But with technology, a lot has changed over the years, especially in recent times. When we speak of effective external communications, we refer to good communication, of which as lawyers, we have to maintain that relationship and reputation by having good communication with our clients. But with that, we give them positive experience. And in to do so, we have to make sure that when we are meeting, for example, new clients, or we're giving them an email update, or we are sending out a bill, we are working under a narrative that communication is communicated in a way that not only adds value to the firm, but adds value to a client. So looking at traditional tools, I've mentioned email communication, where we have the likes of Outlook and Gmail for sharing documents and maintaining records. But we have been using phone and video calls, for which of recent, as you remember, since COVID, Zoom and Microsoft Teams have taken precedent. There are other tools where we have the messaging apps. I know there are some, for example, for us, some clients would require for us to, let's say, create a WhatsApp group for easy communication. We have had that, and it's been efficient because it's fast and convenient. But also social media platforms have been very, very helpful in terms of client engagement and communicating as a tool. So we have been using LinkedIn. I know most of you I've seen on LinkedIn, and how, like us, we are doing articles and we're posting communications to clients and regular updates, of which I feel is of value. But going forward, there have been communication tools that cater for collaborative work, not just for firms, but for external use as well. So I will look into project management softwares as part of that. Collaborative platforms as well. They have been able to assist in terms of documentation sharing ideas, but in real time. But also there are available cloud-based communication tools that cater for where you can communicate with the clients and for them to be able to get updated quickly. So moving to, or starting off with project management, I'll give you an example of what's called Trello, which caters for task management, case management, and customized workflow. What that tool, as a tool for communication, does, it manages tasks, helps with deadlines. So when you're communicating with a client, they can follow up and they know that this matter has a deadline, who is working with or who is working on, and then they can have at least an idea of what is the workflow, and that helps in managing the needs of the client, their expectations, but for them to be able to follow up and for us as lawyers to be efficient. But also there's one that is called Nifty, which has integrated communication channels, which that allows for seamless interactions between lawyers and clients. But then again, you're able to track your work using this tool. So as a client on the other side, you of the software, you are able to use those and know what resources or how much has been allocated for your project once set, but also as to transparency. So a client is involved, hence that adds to communication because they know throughout the legal process what is happening. But another one which is very famous is called Clio. So Clio has been very popular, and I know a couple of firms in Tanzania are also using it. So this one offers very, very efficient matter management, but also when it comes to document management, of which is part also of communication. When you are drafting and then you are sending to a client, and your client will have to respond back with changes, if any, and comments, that adds value. But when you're tracking your time and your billings as well, of which you need to communicate to the client later on, the app is able to do that for you as part of communication. But when you're doing your intake and management, there are so many applications or tools that you could use. For example, there's one that's called Cloudlets, of which helps with the onboarding of the client. So when you are doing your KYC, putting the information on, like the one we have at our office, whereby once the client has been onboarded, it's easy. And once you have like all the information, they are sent back to him with a login email and password for them now to be able to follow through in terms of their matter, who is handling, and what is the progress of their matter. So that automation bit of communication is very key for tools like Cloudlets. Similar to that, there's what is called Lawmatics, which is more or less the same. But it's the beauty of it is that it automates everything in terms of workflow. So you are able to schedule, for example, consultations. Clients are able to do their follow-ups, and you can even be able to interact online in real time. So that sort of like adds that personal touch in terms of communication. But I believe all this it has to be data driven in decision making. So there is a lot of data that is being used, so that also adds to issues that we'll talk about later in terms of data protection. But last but not least, I believe is the case management software as a tool, of which most law firms, I believe, and most young lawyers should look into, like one called Practice Panther, where now you can be able to manage your cases. But there is a client portal that clients can look and follow up on updates regarding their cases, but how much is billed at the moment and things like that. But also Clio, the one I spoke to you about earlier, that also does pretty much the same thing in terms of case management. It assists with the integration with the ecosystem in terms of other tools that you can use, integration with like emailing and the likes, and it's also accessible on mobile, so you can do real-time updating. Let's say you're from the court, you don't need to go to the office. But also there is another one that's called My Case, which is more or less the same, but has an integrated online payment processing, which makes it seamless and efficient for a client in terms of communication. So they know if there's a bill that comes off from the case related, let's say, to payments that are supposed to be done, they can do it on their phone easily. And like in Tanzania now, most of these applications are integrated with tools that allow for payments through MNOs. So that's also, it's something that you should consider. But yes, lastly is on the virtual reception services that now is one of the biggest from video conferencing, the likes of Zoom. But I believe, for example, when we are talking of how we can improve our client interactions, there's one that's called Nexa, which is a virtual receptionist that allows you to not be able to worry about handling your calls and appointments and scheduling, of which it can do for you for like 100 voice minutes for $200. But you can do also call screening, where now you can know who was called and what was routed to which department, and what was the response time rate and things like that, of which is very good and it's very important when you're doing now your feedback and look into if client communication is handled very well. But also there are appointment scheduling softwares of which you can integrate on your emails, of which now allows you to book appointments and for clients to be able to see if you're busy or not, of which now adds value to communication. Instead of calling you, they can pretty much do that from your email address or from your signature. When you send them, they can just simply click on and make arrangements. The video meetings I've already spoke about. I know we are short of time, so I'll skip through. So I believe client engagement is very, very important. It adds that personal client interaction, but there is that efficient information exchange, which is very good. And most clients I know appreciate the convenience and the accessibility that is offered by these tools, especially the virtual ones. So I believe it's very important to know when to automate communications and when not to, especially in the digital age. I know even Senior Mohammed has spoken about it. Yes, automation is fine, but when it comes to clients' communication, it's important to be very thoughtful and make sure that that automated message is very convenient for you and for the client. I'll give you an example. For example, it should be simple and add that more personal touch. But for example, we say it's a good idea to do automated email to clients, for example, or letters. But for clients who are very anxious, they want their matters to be handled now, or they have a matter that is very urgent. It's very much better and advise that you use, or maybe, for example, a reception can provide a more empathetic and understanding tone to a client who is very, very looking into getting feedback, something that has been delayed, rather than using automated ways. So you should know when to and when not to. Lastly, but not least, in terms of what we have spoken about, I believe client feedback is very important when it comes to communication. So please, if you can, make sure that you get a lot of ways like surveys, so that you can get feedback from the communication that you have, because most would pretty much tell you, like the recent data that is shown from Find Law says that since 2020, more highlights have been that nearly half of the businesses have prioritized price over quality. It means that they've shifted to what a customer experience should be. What should your client want to hear from a law firm, and what should you service them in a better way, and how to? So that caters for communication. So I believe, please, if you can, I'll insist, go and use tools like Google Business or Zonka, or have a QR scanner whereby people can come to your reception area, clients, and give you feedback over whether the communication that you are having on how their matters were handled on time. Are they appreciative of your services? Are you able to deliver on time, and things like that? So I'll end up there and hand it back to you, moderator. I believe I've used my 10 minutes. Thank you.
Thank you so much, Senior Counsel Sunday Nabugoba. You have been very punctual. And probably if you have got anything, you can summarize. If in case you forget anything, I can give you a bonus of 1 minute. In case 1 minute, in order I may now proceed.
Oh, thank you very much. Just to summarize, I would say traditional tools, yes, very important. But I believe now with the era whereby everything has to be done faster, everything has to be seamlessly connected, where communication is key. We're dealing with clients every day that demand more of us. I believe there is no other way out than integrating technology. Yes, we can use the conventional ways, the traditional ways of doing phone calls and emails, but these days people, or most of our clients, want to be communicated in ways that matters most to them, knowing that we care about their business, and sending them an email whereby they might be able only to read it, let's say in the evening, but you could send them a text, or you could not be able to update them as once you get to the office, but you could update them about their case, about the ruling that came in court in the afternoon, and they get to receive it as you're coming off court. Let's say you're driving back to the office. I believe that is very key. So with that, I also wanted to speak of what I believe is very, very best to do, apart from feedback, apart from what Senior Counsel has spoken about, in terms of the listening skills. Very, very important for you to be able to know that when you're speaking to someone, when you're speaking to a client, you are supposed to be very, very active in terms of listening, but look at them in the eye, and so that they know that you're actually talking to them and are appreciative of their matter. But that peer, I believe you also need to cater for how to manage crisis in terms of communication. So as a law firm, as lawyers, yes, we talk about these tools and what we use and what not to use, but you should be able and look or be prepared of what happens when these tools are not working for you. What can you do? What happens? So if you cannot reach a client by call, you can do it by email.
Thank you so much. Thank you so much.
And there.
Thank you so much, Mr. Sunday. In a brief context that you have really enlightened us, Mr. Sunday, and Senior Counsel, that we must, a note taken for anyone who have just joined late with us, a note taken that you must have a communication with the clients. In communication, you must not do a traditional mode of it. You must use digital emails and correspondence, but also meeting the client expectations. You must also see how the feedback goes on the correspondence between you and the client. You must look for the potentialities. You must also, he has also shake hands with the past speakers on the issues of trust and confidentiality. So that is what briefly Mr. Senior Counsel has just taken us through. But also, besides, he has emphasized that you must narrow down to expertise area. You must have your expertise areas in order you may magnify yourself in the practice of how to get a client and how to handle the client too. And this also goes with the Senior Counsel Mohammed. He once said here in the presentation that it's more recommendable when you say that you need to save the client, and when the client goes to tell another victim who is a client and a new client that this is a good advocate, the passive message of the client testimony, it works so hard and is really working, and it is more powerful. So Mr. Sunday, Senior Counsel, we really thank you so much. And I hope you stay on tune because we'll come for the second session of deliberation and questions. So it's my humble prayer that I welcome Mr. Makua to proceed to introduce the next speaker. Welcome, Mr. Makua.
Thank you, Mr. Ukashi. Our next speaker is Mr. Colin Gatete. Mr. Colin Gatete is a practicing advocate and managing partner at Colin & Colin. He holds a master's degree in international commercial and arbitration law from Stockholm University in Sweden, and a bachelor's degree in law from the Catholic University of Eastern Africa, Nairobi, Kenya. And I must add, he was a graduate magna cum laude. He has successfully taken advanced trainings in complex commercial transactions from the African Legal Support Facility Academy, and holds a certificate in international criminal law from Nuremberg Principles Academy. Before joining the firm, Colin was previously at Rukangira Law Chambers, as well as the African Legal Network that is part of the Anjawala Law Firm, the National Public Prosecution, and Bank of Kigali. He has expertise and experience in commercial transactions, employment, legal advisory and consultancy, intellectual property, taxation, and dispute resolution. Colin is also a lecturer at the School of Law, University of Kigali. I take this very humble duty to invite Mr. Colin to speak to us this afternoon. Karibu sana, Mr. Colin.
Okay, thank you so much. Can you hear me?
Yes, please.
Okay, so I think I'll also use my 10 minutes quite well. First of all, thank you very much for the previous speakers. You did a very good job. You touched on some of the key issues that also affect the what I'm going to be discussing. So the theme today, or the topic, is about strategies for young lawyers on communicating, creating, and developing good client relationships. my able colleagues have, my able presenters who spoke before me have clearly, brought out some of these important aspects. And so my part on, or what I will focus more on, is more about the impact that the AI, or artificial intelligence, and automation has had on the communication and elevating client relationships in this day and age. Now, like most of the presenters mentioned, we cannot ignore the trend, or the where we are heading. Where we are heading is very tech dependent, is very is becoming more and more automated. It's becoming more. There's more and more use of computers, and now we've reached the point where we are now using computers to, computer systems particularly, to make them to be capable, to make, to perform complex tasks, particularly those that require human intelligence. Now, so my topic, like I mentioned, is going to be particularly about the impact of artificial intelligence on the communication of client relationships. Now, like the other panelists mentioned before, client communication is very, very key. Right from the beginning, right from the time you walk in, right from the time you say hello, and then it will, that alone can influence whether they're going to, keep a discussion with you, whether they're going to hire you, whether they're going to retain you as their lawyer. Now, the artificial intelligence in this day and age has changed a bit of how things are being done. For example, since COVID, or not just artificial intelligence, but technology as a whole, since COVID 2020, there's been a big shift on communication with clients, either new, existing, and previous, online. So in other words, there's a lot of this kind of discussion we're having virtually. So we have had today, it is very, very, very possible to have a matter begin right from the beginning, right from the time you meet a client, all the way to the time you close a transaction, without physically meeting the client. We've had one particular, Rwanda has done a lot of, has made this very, very possible. So basically, you can literally, open companies without being here. You can register intellectual property without being here. We can do a lot. We can do a lot without being here. In fact, there are some companies which we assist to exist in Rwanda, in fact, and do some work in Rwanda, get paid in Rwanda, while the people behind it are not in Rwanda. Why? Simply because of this artificial intelligence that is operating. And now, as a lawyer, as a counsel, as counsel assisting these clients, right from the beginning, you can have this kind of transaction happening, payments done, instructions coming in, reporting to the client, all the way to closure when you haven't met them. So this alone is one impact, but we shall look at it in detail as we proceed. So before I get into much into further details, let's try to see what are the definitions of what artificial intelligence means. So artificial intelligence, like I described above, is basically computer systems capable of performing complex tasks that historically only humans could do. And some of the tasks that they do, interestingly, are what lawyers are hired to do. 1, reasoning. 2, making decisions. 3, solving problems. This is what lawyers are hired to do. This is what we go to, we as lawyers, we go to court, or even our clients go to court to do. They go there for decision making. They go there to help to resolve their problems, and to to help them align their reasoning in a way that is appropriate to a specific jurisdiction. Now, today we have a situation where we have computers or computer systems, specifically AI and also automation, doing this work, doing the reasoning. So basically, you present an issue, it will reason and give feedback, make decisions, solve problems. So, particularly for the legal work, this artificial intelligence is now doing a little bit more work in terms of document analysis, legal research, and predictive analysis. Now, these 3 are most of the work. If you look at the work that the AI is doing, is mostly autonomous, but again, it will have an impact on how we communicate to our client. Because if you look at how we communicate to our client today, it has become more of because most of these clients, especially if you're specialized, someone was mentioning earlier about specialization. If you're in a specialized specialized area of law, chances are you're going to be having routine or regular kind of queries, kind of instructions from clients. So the kind of communication you do tends to be similar to the one you did the day before. So, like I mentioned, things to do with the document review. If you're in a specific area, there's a lot of this being done with AI applications. My colleagues, I think it was Council Sunday, who mentioned some of the applications we have today. They've been developed to address specific areas. So if you look at research tools, they mentioned some, Westlaw, LexisNexis, Ross Intelligence, and so on. If you look at things to do with contract analysis, AI to do with contract analysis and review, Killer Systems, LawGeek, which is very not usually used for students. Then we have document automation, which almost helps to put documents together, including creating legal documents such as submissions in some jurisdictions. In this part of the world, in Africa, I've not seen much of that, but in some other parts, Australia and America and Canada, there's been automated apps which help produce submissions. Now, this is, on one end, this is a development that is coming in and that we should be looking out. And then things to do with, say, discovery, what they call discovery again, trying to find evidences from both parties, exchanging of data and information, especially in litigation. There's also been apps for that. There's apps for and then all the way to reporting. So reporting is being done by chat boxes. Someone was mentioned, which is more of virtual assistant or automated, responsive. So the chat boxes, there's one called Do Not Play. There's a Law Droid. All of these, they provide basic advice, answer common legal questions, and basically do what the client would have called you to do over the phone. Now, on one end, these are on upside. We shall look at. It also has its downsides, but what I'm trying to say here is that these apps have been developed to address a lot of these issues, especially so far. They've been in the developed world, first world countries, especially in the northern hemisphere. There's a lot of that. Now, AI has been good. Of course, we cannot downplay the benefits. It has made some of our work easier. Some of us are already using some of these platforms, these softwares, and to some extent, something that's supposed to have been done in 5 hours or 1 day and so on can easily be done in 30 minutes. Now, these kind of benefits that come with AI include the efficiency. So basically, you save time. If I'm supposed to be spending, 30 minutes and I'm here doing, sorry, I'm supposed to be spending 5 hours and I'm doing 30 minutes. That means you are able to do things not only faster, but also you're also able to in that, and therefore it also increases generation of revenue as a firm because you're able to do a lot more in a short time. Then also, of course, the quality. Now, lawyers, today as we speak, from my experience, and I think I share the same experience with other practitioners, the quality in terms of errors and is still the computers are faster, but they especially in law where you have to be precise, where you have to refer to legal authorities, where you have to refer to specific provisions. They've been falling very behind on that. So there's still a gap there, especially in our part of the world. In North America, tends to be better. But what am I trying to say here? Is that in as much as the quality has increased, we shall look at it later, that we still need this human interaction. So the quality has reduced, the degree of errors has reduced, but they still make errors, and these errors must need a human, to come and address them and make sure they align with what exactly you're looking for. Then other things such as cost, I've explained, creativity. Mokua, how much time do I have?
Yes, you have less than a minute, sir.
Less than a minute. Okay, I'll be quick. Now, let me quick just to wind up on this. So after looking at all of these things that have developed and all of these, apps, the lawyers rely on AI? Oh, yes, for sure. You cannot ignore the where we're heading, like I said in the beginning. But some of the things that Council Mohamed Nyaoga was mentioning, and I think Sunday mentioned, you will lack some of these things. For example, we'll lack human emotional intelligence. You will agree with me that when a client comes to your office, there's a lot you read from them. Some of them will come very worried, happy, excited, concerned, angry. All of this, they give direction on where you're supposed to be, on how urgent, how important, how valuable, how, it gives context. Now, the lack of human judgment and human and emotional intelligence is the downside of one of these AIs. Then there's issues of privacy. Now, remember, you're sharing this information, you're putting some of these things on the cloud, you're putting some of these things online, and some of these things are supposed to be confidential. Now, these online platforms will claim they're safe, but again, we've heard of many instances where they've been hacked. And so you get, client files exposed to potential breaches of privacy. And not just that, I'm going to be very quick. Then contextual understanding. The AI to date has a degree of limited contextual understanding. Even if you have as good prompts as you may want, there's always going to be more understanding that will require human input. And I think those of you who have been able to use most of these AI and automated apps, you will agree with me on that. So there's a limited contextual understanding. And then lastly, there's a loss of human interaction. Now, human interaction is very important because, again, like Muhammad Nyaoga mentioned earlier, and the other panelists, when you meet in person, it gives a lot of context. It gives a lot of you will be able to understand more than it would be if it was in person. So these are all downsides, but again, we can only see how to complement the AI and see and automated intelligence to see that our clients are better served in terms of efficient communication and efficient and effective communication. Now, I will stop there for now, and I will maybe say something at a much later stage. Thank you very much, Mokua.
Thank you so much, Collie. It was a wonderful presentation, and unlike to other speakers or presenters, you have come in your unique way of seeing how we use AI and the human interaction effects, of which that has been taken note. To my side, I have to briefly say something briefly about my experience for the young lawyers in relation to the communication strategies. One is that, first of all, we young lawyers, most of us, we are not well trained to accommodate the structure of communication between us and clients. You can find a client is a corporate person. He needs you to be on timely basis. You are not in time. It may reach in the correspondence. For instance, a client can write to you an email that, please, I need to review my MOU. At this moment, please give me a feedback. And you just reply, okay, thank you. Now you can find out that if it's a potential client, you can just twist your mind that he's not dealing with a serious person. There are some issues of correspondence. For instance, you can say highly noted. What have you noted if there's an assignment? Something like that. But also there is the issues of client expectations. A lot of clients, when it comes to you, the first and foremost thing is that he or she expects the best services from you, from how you treat, from the way you have researched from his case or scenario, to the stage of advising and whatever. Now, in that situation, there's a lot of constraints because we might not be reading or making a research. Probably you're not even consulting the seniors. So you end up giving a client who is very intelligent a very, very minute or a very demeaning answers or correspondence of a legal, which you cannot take or she cannot take. But also there's issues of culture issues of that. There's a client who needs to be there whenever or to be informed whatever the advocate is doing. Now, it is very tedious because it can attract you to somehow comfort the client and whatever. So you need to be having an empath on such a situation as a young lawyer. But there's issues of fees and costs. You can find how you charge and billing. For instance, you can say that you're a young lawyer, you can charge below. When you charge the low rate, you think the client can come to you, but a serious client who knows the nature of the job, he cannot take you. You can say, for instance, a job is worthy, maybe let's say 5,000 US dollars, and you say, I'm charging you 1,000. For a serious client, they can ask you, do you really know this job? Or probably you might not do the job properly. You can lose that client. So it's not fair that at all costs, you can just negotiate and be very low price. So another thing is about branding. The issue of branding goes to the office, goes to the nature of your mentorship. It goes wide the outlook, appearance. It goes how are you putting yourself in the platform of interaction with the clients. For instance, you are only living in the street, talking to the marketers. You'll get the client from the marketers. But if you have extend yourself to be a corporate, that means you'll get some very, very nature of client on that angle. And that goes with adding more knowledges. So this is what I just extracted and I wish to share for my fellow young lawyers. We need to twist ourselves. But to the least, you can see that how do you put yourself as a composed person? Because you can ask a person, maybe, do you know this? And then you state, oh, me, and then you reply. For a serious person who looks at your demeanor can just get a doubt. You are not competent, or you don't know what you want to tell me. You are not updating yourself. So this calls that we need to brand with this particular training and they know the mode of communication. Even in the phone, you must know if he's a client, you must talk formal issues. You cannot ask your client, have you eaten? That's not about the communication you have to encounter in your strategies of a client, or you should not be too darling to your client. No, you must create a Chinese wall between a client and a lawyer advocate. So this is just a brief thing that I've extracted, and more will continue to share. Let me turn the button to my friend Mokua to proceed.
Thank you, Mr. Ukashu, for the wonderful thoughts. Now we are going to get into our next session, which is the Q&A session. And if you allow me, I wish probably to read the questions that have been posted on the platform. And I wish to invite all the attendees to use the Q&A section. And if you want to speak, could raise your hand so that we can identify you and our technical team will enable you to speak. So without further ado, I'd wish to read the question from Ruth Washuka on how should one deal with difficult clients like those who want to micromanage you on every step of the way and check each and every step of a matter you're handling for them. Others would want you to handle their matter their way and the best way you know as a lawyer, and not the best way you know as a lawyer. So I think this question is shot at any of the panelists. So I think one of the volunteer panelists can handle that before we invite further speakers. We have 28 minutes to go, and therefore, yes, I can see Senior Counsel has unmuted himself.
If you wish, yeah. Thank you. In the nature of our work, we'll encounter different types of clients. Some difficult, some a little cunning, but you as a lawyer must be discerning. Some clients will try and micromanage you. I think you as a lawyer hold a huge professional responsibility to do your job because you are the expert. You are the expert. There are cases where clients come to you and they withhold information. And you proceed to court, you prepare affidavits on the basis of the information that the client has given you. And after you file the pleadings, you discover that there's something the client didn't tell you. And if you lose the case, the client will blame you. You need to be very clear from the onset. You need to manage expectations from the onset where you tell the client, this is how I want to work with you. You must make full disclosure. I am the lawyer here. You give me information and I'll advise you based on the information you have given me. So you must be in charge. If you allow the client to be in charge, then there is a problem. And if the client trusts you as a professional, they must allow you to do your job. Otherwise, you end up embarrassing yourself. Thank you.
Thank you, Senior Counsel. I can see two attendees, Neema Saruni and Malo. You will forgive me because my tongue is a bit heavy and some of these names are a bit problematic for me. So I'd invite the technical team to unmute, enable the two to shoot their question. Yes, you've been enabled. You can unmute. Neema, you can unmute, and then you shoot your question. You can also choose which panel speaker would want to answer your question. Neema, you can unmute yourself. Malo as Nema.
Hello.
Yes, we can hear you, Nema.
It's not a question. I was asking for the notes for the previous.
Okay, we will ask the panel speakers to share the notes so that we can share with you.
Yes,
sure
that was my concern. Yeah.
Thank you. Bajel Malo. Bajel. As Bajel also unmutes, we could also unmute or enable Catherine Simon to be able to speak.
Hello, yeah, this is Catherine.
Yes, Catherine.
Thank you so much for the informative session. I just wanted to ask, in terms of the communication, the senior counsel was talking previously about breach of trust. Not breach of trust, but once you miscommunicate or you show in some way that, for example, like you're supposed to show at the court at a certain time and you don't do that, or things like that, and you've already lost the trust of your client. So I'm quite curious about, it hasn't happened before, but I just want to know, for a young lawyer, if this situation happens, what can you do again? Because you still continue to be an advocate, right? Or you're still finding your way in the career, and it's not easy. So how do you regain the trust? How do you work again on building that trust with that client specifically, or any other client, in a situation where it has already gone out there, like, okay, this advocate is not serious, or they are not trustworthy, or things like that. Thank you.
Thank you. Before we give another person to speak, that is Shema Stephen. Elma, you can enable her to speak. There's another question that has been shot on the Q&A section, and this one will also to all the panelists. I think I'd invite for gender balance, I'll invite Ms. Namuli to answer this one. From practical experience, what's the best way or technique to calmly and efficiently charge the clients without being seen as overcharging or undercharging? So we could allow Stephen to speak before the speakers can take the questions. I think one question is to Ms. Namuli, one has been directed to Senior Counsel Nyaoga, and then we'll take from Shema Stephen. Shema, you can proceed.
Thank you. This is Shema Stephen. I'm Pescare from Ghana. So I rank the session of today as the best way we can handle the clients to meet their needs. For me, I had a question I wanted to ask one of the panelists. So we remember that what I learned, clients are not our friends. Clients may, in some cases, may discourage us giving false information such that we collaborate with them, we assisting them or giving them a legal opinion based on their will, rather than that are not provided in laws. So how would someone in practice deal with such a clients who are not cooperating?
Yes, you can kindly come up with the question again. The last bit, I didn't get the last bit.
So I was saying that clients are not our friends.
Yes.
Even though we have trust with clients and being self-confident, some clients may mislead us through the communication we are using in order to assist them. For instance, when a client wants to dismiss one of his or her employees, then he's an employer. Then he wants you to collaborate, thinking that you advise them that they should chase or dismiss their employee with legal opinion you gave them, yet it's not legal. How should we manage to deal with that such clients?
Thank you. I think we can, any of the panelists can pick up that question, and I'd suggest maybe Mr. Sunday Ndamugoba, as I also cede ground to my colleague, Mr. Ukashu, to moderate the next bit of the webinar.
Okay, thank you so much. And I'll just have some few keynote that Mr. Sunday Namugoba can just handle and answer for us. For instance, I can just ask Mr. Sunday Namugoba to say, what are the different tools for effective communication with the client that young lawyers must embrace? And second question might be, which communication tools, in your view, senior counsel, should never be used for the high value client? Or how best can these tools be harnessed to ensure proper client relationship? And the third one is, in your view, as the social media enhanced or contributed to the deteriorated client relationship among the Gen Z and millennials lawyers? What's your view on that? Or maybe I reframe it, how do you see the contribution of using social media? But you can begin with the first question first, that what are the different tools for effective communication with clients that young lawyers must embrace? Welcome. Just you have got only 2 minutes, senior counsel. I hope your economy in time.
Thank you very much. So I'll just go quickly. So on which tools I had mentioned previously on my presentation, I believe we use traditional tools and non-traditional tools. So the likes of emailing, or making phone calls, personal visits to clients. But then again, we use now what we call modern tools of communication. I've spoken of how we can use video conferencing, how we can use automated secretaries or receptionists. So those are the tools. But there are tools also that caters for client management. We call them CRM, for example. So those ones you should embrace on using softwares to cater for that. But also, I believe, like my colleague, what he was saying in terms of technology, I believe, and I subscribe to what Colin is saying, use AI as much as you can as a tool as well for communication. So I would say embrace as much as we can the likes of Clio. I've mentioned, I will share my presentation for you to be able to assist your clients. But which tools you shouldn't be using for very high value clients, I believe the likes of WhatsApp, for example. So depending on who you're talking to, it could be Bill Gates, for example. You cannot chat with him on WhatsApp unless you've established a form of communication via email. So depending on which clients, but always as lawyers, we have to maintain our nobility in terms of our profession. But as a profession, you should be able to engage or establish communication early on in ways that are more professional friendly, I would say. So an email, and then later on you can move your conversation elsewhere, whether it's by using tools like mobile phones, where you can use chat tools like WhatsApp and the likes. On the last one, on use of social media as way of communication, I believe yes, times have changed. Now technology is everywhere. I know we have unconventional ways of doing things, but if you lag behind from not using the tools that are available now, you'll be left behind. So I'm saying use tech now, use the ways that I know we keep on blaming and saying it's the Gen Z way, but it's not just the Gen Z way in how they do. Even Gen Alpha will come and use it as well, but millennials and the like should be able to embrace technology and use social media as a way of communicating. They say there's a legal update. You can post it on Instagram and there's more tracking and reach more audience, and even your clients will be able to see that, or your WhatsApp status, they'll be able to see that. So it might look unconventional, but it's one way of communicating and people to know that you are doing something. And quickly to go over the questions that were highlighted or questioned on the chat. For example, your name has been smeared. What to do? I believe rebuild the relationship. If you did something that was not to, or it was damaging to your brand, I believe you need to rebuild that brand, starting with the brand that you did to. So probably offer some service, let's say for free on the next one, and then try and do good in terms of your relationship and build it across. And what if a client hasn't paid? What to do? I say use tech. For some clients, for example, for us, what we do, we automate our invoices. So if you don't respond to the first invoice, then the first invoice has an automation after 7 days. After that, if you're not paid, then it keeps on reminding you every day. It's very annoying to the fact that at some point a client would pay, but we look at which and what client who wouldn't and wouldn't pay. So because there are clients like you're talking of, I saw a question about bad clients. So if it's a bad client, you have to know your clients first, because you cannot serve each and every client. So pick a client to serve and one not to serve. So if a client is very bad and you know that it's going to ruin your reputation, or you cannot work with, you are better off just leaving them aside. How to change how not to charge when you're overcharging. You feel like you're overcharging. I believe for that question, when you feel like you're overcharging, our rules guides us on what to charge and what not to charge. So I would say best not to go beyond, but if the task is very hard or a client does not understand you in terms of, if you're supposed to charge less than $2,000 for a company corporation, and you have to show them why you're charging $2,000. So instead of saying $200 for a incorporation of a company, I would say break it down to, let's say, preparation of MEMATs, so drafting of memorandum of association, drafting of company forms, then responding to registry queries or responses, things like the likes of editing perhaps, or meetings that you have to discuss. So if you can break it down to like 7 or 6 things that you'll be doing, then it's easier because human minds have a tendency of understanding or appreciating something that is of value when there are a lot of things that are being done instead of like highlighting just one. That's it, I believe. How to get new clients? I saw that question. I would say there is no one way or the other that would beat another one. Like senior counsel was talking about referrals. If you do one good job, I'm sure you get another one next, because they'll refer you to. But embrace technology. There are so many tools that you can use to do so. You can't be a new law firm or a new lawyer, or let's say just coming off from starting your practice, and you have not read books of how to do and what has been done before. Sorry?
I hope you are winding up.
Yes, that's that. I was saying how to get new clients. So have a website, embrace technology, but also appreciate the fact that you have to deliver goods so that you can be referred and get referred. But also join networks that can allow you to be able to get clients from different jurisdictions. That would be that for now.
Makua, I welcome you. Please, you can proceed.
Thank you, sir. Thank you, sir. There are questions that had been asked to and allocated specific speakers, and I'd wish that they are answered first before we proceed. one speaker asked, how do you regain trust once lost? And I think this one was directed straight to senior counsel. And then this one we allocated Ms. Namuli. How do you charge a client without confidence and without looking to overcharge or to undercharge? So I'd first of all invite senior counsel, and then Ms. Namuli will come next.
How to regain trust? Thank you. I'll answer that one. You didn't appear in court. I think that's how Catherine put the question. So there's breach of trust. How do you regain it? First, why, and how did that happen? Is it because there was no proper communication with the client, or is it because your car broke down, or is it because you found yourself in custody? You are not able to appear in court, or you are impaired in one way or the other. Now,
Senior counsel, I might interject you also. As you answer, there's also a question for you in the chat section. So you can also look at it and maybe use
the
this
one on money laundering?
Yeah, the one on the limit with which you can work with a client who is a criminal. The one that is
Okay. Yeah, I've seen that question. Yeah, So I think most importantly, if you have not been able to appear in court for whatever reason it is, you need to explain yourself to the client transparently. You must explain what happened, but more importantly, you must take steps to remedy whatever prejudicial orders may have been issued for your lack of attendance in court. If adverse action has been taken, you must take responsibility. Do not try to apportion blame. Be as transparent and open to the client as possible. If you do that and remedy the situation or whatever adverse action may have been taken, then you may start building the trust again with the client. Now, the other question, I want to add on something on social media. For social media, I've seen a lot of lawyers post even the cash they have been given by the client. They say, I've received this cash, I'm going to bank it from the client. And they even post the banking slip. Now, quite clearly, clients don't like to be associated with bad brands. Because if you do that, you become a bad brand, and therefore you pollute their brand. You must try to use social media responsibly. You must, when you post, you must ensure that the posts that you put out there are not sensitive to the client, because you are working in an ecosystem where you are responsible to other stakeholders.